The Free Speech Podcast is an initiative of SFLC.in under the Free Speech Project to understand the changing landscape of free speech in an internet enabled world. We have spoken to a host of journalists, activists, lawyers, and scholars to understand and rethink our current landscape around free speech in India.
Today we have Mr. Saurabh Kirpal, who is a senior advocate, a LGBTQI activist, and author of the book Sex and the Supreme Court. He has been the leading lawyer in a number of landmark judgments, such as Navtej Singh Johar and Ritu Dalmia. Welcome, Saurabh. We're very, very happy to have you with us today.
Thanks, thanks for having me.
Of course. So my first question to you is that that there is this question of horizontal application of Article 19, freedom of speech and expression, which has come up before the Supreme Court in the matter of recently in the matter of Kaushal Kishore. On our website, on our free speech tracker, we maintain this list of restricted social media policies that a number of private organizations impose on their employees. Basically, what do you post on social media, what do you not post. We've also seen that happening with universities, which we believe is a curtailment of of free speech and expression. But can you tell us what does this horizontal application of Article 19 mean, and does our constitution allow for it?
Well, when the Constitution was promulgated, each citizen got rights. But when you have a right, there has to be someone on whom there is a corresponding duty. And that duty lies upon the state. So typically, the Constitution worked in a way that each individual had a right to say free speech or right to travel, right to life. And that right could not be curtailed by the state or the government or any executive authority. So the restrictions were always imposed on the state actors from infringing or acting in any manner which restricted the right of the individual. So the right vests in the individual, and the restriction is cast upon the state. Now, this is the traditional understanding and conception of fundamental rights, and this is called a vertical application. I suppose you'd say that because the state or the law is above you and the individual is below that. So that's probably one reason as to why people use this terminology. A horizontal application of fundamental rights is something which is a right that one citizen will claim against another, right? So you don't claim a right of free speech against the state and say the state is infringing my right. You will say there's another entity which is in the private domain. It could be, of course, another individual, or as you said, another company or some university, which is acting to curtail your rights. And then you say that this curtailment of my right by a fellow citizen or a fellow entity is a violation. And this is not only true for fundamental right of free speech, but it could be for a variety of rights. So your right to business could be impinged by some another company. So the examples are multifold. Now, I am a traditionalist in this one. I don't believe that the Constitution envisages a direct application of horizontal rights. I don't think, and that is clear from the language of the article itself. The plain reading of the Constitution. You can bend anything when you want to, but if you read plain English, then there is no scope really, or at least in the case of freedom of expression, for there to be horizontal application. Uh, Having said that, that may be the position in law that I can't claim a right, a fundamental right against, say, the company or a university. One of the reasons would be that the university will say, well, it's my right also to say or to regulate how speech works. So then you have two competing Article 19(1)(a) rights, and you have two competing 19(2) restrictions. Another reason could be that I could say I don't want to be bullied by you. The other person will say, well, I can bully you because bullying does not fall within the classic exceptions to the free speech, right? So you won't be able to use the Article 19 formula really to control bullying and such like things. But that doesn't mean that just because the Constitution does not have horizontal application of fundamental rights, is that we throw the baby out with the bathwater. There is, I think, in my view, something known as indirect application of horizontal rights, which is that there's an obligation cast upon the state to create an environment through regulations, laws, or other mechanisms that the right of a citizen to have free speech is fulfilled in a meaningful way, right? So they must enact a law which prohibits bullying. So while the law would be made by the state, if it is challenged, it will be judged by as an act of parliament. It will be challenged on the traditional vertical mechanism, but its application will be between individuals. Right? We know that very often when we see defamation, it's one person's free speech against another person's right to their autonomy and dignity. But and that's application is horizontal. But there is a law of defamation, which is a state law. So again, in practice, it may be have horizontal application, but in law, it is technically a vertical application, and that is imperative, I think, because 19.2 is a way to control free speech. I don't want laws and courts to start now going after individuals and saying that using 19.2, because you are offending someone else's free speech, I'm going to control you. I'm very wary of giving expansive powers to the court or to the legislature in this regard. So that's what I would say on vertical application and horizontal
Right.
application of
Yeah.
rights.
All right. I think that's a very interesting way to look at it. If tomorrow, because courts are considering the horizontal application of free speech, what will be the consequences if tomorrow, legally and socially, Article 19 is applied horizontally, especially in the context of digital regime? Because like our public spaces have expanded way beyond what was traditionally thought of public spaces.
Right. Now, again, I think I may differ from you on this one. I don't believe in the horizontal application will help directly free speech in the digital space, because it will give the government and the courts power to step in and start regulating media, not because you're protecting someone's free speech. You will say we're actually just using our 19.2 powers, our powers of restriction. Now, how does a right to free speech work? It is a fundamental right which vests in you, and there are certain controlling features which are there in 19.2, which are the restriction, reasonable restrictions, right? So there's a right and corresponding limitations. The limitations don't ever vest on the individual. Now, if you start allowing a digital platform to be regulated as a private entity akin to the state, then I can, supposing I'm a powerful individual and I don't like what someone is saying. So I won't have to go through the traditional norms of defamation, proving the evidence. I can probably move the Supreme Court directly or some court directly and say, look, this digital platform is abusing my right. And the court will then start doing an analysis of reasonable restrictions on that particular entity. Now, that in the meanwhile, that entity also has a right to regulate as to what is put on its platform or manage its own digital platform. And what happens to that right? So now that right just gets thrown out of the window, because in the aim of protecting the individual right of an individual, you are going to efface totally the freedom of expression which belongs to the digital platform. Now, there are many instances of abuses that a digital platform does, where you wrongly throw people out, and those digital platforms need to be held to account. But that is, I think, by far an exception. The general rule is that these digital platforms need more freedom, not less. So I think a horizontal application is a very dangerous weapon, which, if used for digital media, will be inevitably misapplied by a government, which will always want to overreach itself. They are very happy to give themselves another tool to control digital media, and that just takes their power, their requirement of regulation away. Please control everything. You have all the powers under 19 to regulate social media through enactment of regulations and laws. But it would be inconvenient, because that would require a framework to be put in place which would be applicable to everybody. And it will take away the discretion the government has to go after certain digital platforms and claim a 19(1)(a) right. So that's the worry that I have, that it can be misused.
Right. Yeah. Even in whatever we've observed, like this competition between misinformation, that's the biggest problem that we're today facing in the free speech area, and the right to free speech. There is no clear answer. Like different jurisdictions have come up with the different things that say so many different things, but there's no there's no band-aid and there's no fixing formula that we've discovered right now. And I think we're all just trying to scramble around figuring out how do we maintain free speech in the light of this new medium. Can you tell us, the importance of freedom of speech in the digital sphere for the LGBTQI plus movement? What are the consequences of inaccessibility of the same? There is a lot of online harassment that happens. There's a lot of hate targeted, especially towards the marginalized communities. And how does it affect their access to these spaces, which, these public spaces, internet enabled platforms, social media platforms, are the places where these communities have actually felt safer. These spaces were supposed to be liberating and these spaces were supposed to be open, but unfortunately they're becoming hate filled and they're becoming targeting. How do you see this panning out over a longer period of time?
Right. Now, so before there was internet, and when most of your audience were probably not born, people like me and all, we did not have the internet, right? And it was very difficult to form any sense of community uh, within the LGBTQIA community. Uh, and it's I'm not talking just of the fact that today people can go on dating apps and find people to have sex with, but even as a sense of a community, as a safe space, as you said, there was really a few institutions or organizations where one could go, but that was geographically limited, right? So if you were in a big city and you weren't scared of going into a particular building, then you could do that. But most people didn't have that access, right? If you were from a smaller town, or you were scared to be seen entering a building, you didn't really have access to resources of a person of an alternate sexuality might have had. So the internet was a great liberating force, really, in that regard. It brought people together, and also for young children growing up, or people who are confused about the sexuality, to see on the net that there are other people like them. It gives them comfort in the knowledge that you're not alone in the world and you're not completely mad. And so the net has done a lot of good thing, which is why we need to protect it, to ensure continued access to safe spaces in the community. And you're right, there are increasingly, the more powerful a weapon gets, the more powerful the pushback will also be. So there's so many people now expressing their sexuality openly on various digital platforms and social media, that there are going to be trolls and people, instances of cyberbullying, particularly, or blackmailing, etc. So there is misuse, undoubtedly. Now, there again, I think this is not unique to the LGBTQIA community. This happens to virtually vast numbers of women. I think most women will understand what it is. Even if you're not trolled, the threat of being trolled or the threat of being abused online is a sufficient deterrent often for you to refrain from saying that you wish to say, right? So these are problems that are endemic to everybody, and for that we need certain controls, which is uh, not only a government control, which is, of course, the government should set base standards as to how and what constitutes bullying, but you also need the courts to be more sympathetic, and we need the courts to be a bit quicker to act in instances of bullying. The judicial process or the legal process takes its own time, and by the time anyone manages to go to the police, register an FIR, the matter is heard in court, the court gives a direction of a takedown order, then a lot of time is lost. So the judicial process is extremely slow. Uh, by the time you go to the police and register an FIR, the matter goes to court, the court issues an order for a takedown order. Uh, a lot of time passes, and in that time, the psyche of a young child can be very adversely affected. So we need the courts to be responsive. We need the police to be more responsive as well in dealing with instances of bullying. But above all, I think we need these social media companies to be actually far more proactive than they have been. Uh, Anyone who's had their account hacked or has faced trolling, and if there are people who don't have 1 million followers, if they were to write to the social media platforms of a particular or the complaints part of their platform, you'll find them fairly unresponsive. Days can go by before they write anything, or they'll use a ham-handed thing of blocking everything about a queer person. And that's very simple, because they don't wish to spend the money to regulate. Regulation costs social media companies money. And the one thing these social media companies do is to earn money. I mean, let's not get away from that fact. That's their business model. They want to earn money, and they don't consequently want to spend money on regulation. So there must be laws which require social medias to companies to have a very robust monitoring system. There's some figures I was reading that virtually the entire amount of the regulation that is done by Meta and Instagram is spent in the US. In the South Asian countries, India particularly, gets a very low component of the total expenditure that is made on regulation for the Indian subcontinent, even though the vast majority of its users are here. So it's just insufficient regulation. So we need intervention at all three levels, which is the government by way of regulation. We need the executive implementing authority, which is the police and the courts. And we need ultimately the private players, which are the digital platforms, to be more proactive than they have been in the past.
In our experience, whenever there have been victims of cyber harassment who have approached us, we have realized the police to be quite unresponsive. The cyber cells mostly, there are no, not all police stations have cyber cells. They are mostly victims are deterred from registering complaints, and that's a big problem. Especially
Right.
for these young schoolgirls who've just gotten who use shared devices to access education. I mean, we find that it's been a big problem for them. So my last question to you is, and this is the question that we ask all of our guests on this podcast, that do you think in an internet-enabled era, the right to speech can be absolute without, 1902? Would such a model work for India?
Well, I think the obvious answer for that is no. We can't have an absolute right to free speech. And it's not just about going into a crowded cinema and shouting fire and causing a stampede or inciting violence, which will cause other people's. Because we live in a society. No man is an island. No woman is an island. And if you live in society, you obviously have to have certain structures and rules in place, and obviously different rights have to be balanced together. And free speech therefore cannot be absolute, because it will inevitably clash with other rights, and therefore it needs to be controlled, it needs to be regulated. After all, bullying and intimidation is also free speech, right? So when a person goes and bullies another person by writing nasty things on his or her social media profile, the bullier will say, well, it's my free speech, how can you stop me? And there's a direct clash there between the free speech of the bullier and the bullied. So obviously that therefore it can't be absolute. But I just say one thing here. I think in a quest to balance this free speech, which I think everybody agrees pretty much unanimously that free speech is not absolute, I think we've gone too far into the realm of regulation. We are too quick to give up our rights. We in India have the ban culture. When it gets too difficult to regulate, or we just say ban it. Everything is ban, prohibition, ban, etc. And we've lost, therefore, the culture of what it means to be truly free and truly have free speech. Uh, and that is reflective of how we are today living our lives with a lot of fear, and some people with intimidation. We don't have a coherent body of law which will robustly protect free speech. So I think while free speech is not absolute, I think it's very close to being absolute. I cannot stress that enough, that you can restrict anything, yes, but I think we just restrict too much, too often, too excessively. And these restrictions must be curtailed, and we must generate an ethos of respect to fundamental rights in India. We just give away and barter away our freedom of expression and all our other freedoms at the altar of national security, at the altar of government need, public interest. There are a million rubrics that can be used, or excuses that can be used to take your right away, either chip at a time or wholesale. And it's time we stood up and said no. And I think that's where the courts have let us down. I think the courts have sat back and permitted this erosion of our right to take place without stepping in and fulfilling the constitutional duty. That's,
I cannot agree with you more on this, considering we vastly, just the number of internet shutdowns prove that we're just too quick to, find alternate remedies. It's like the fastest, easiest thing is to ban something.
it's low hanging.
Thank
It
you.
just Yeah, it just looks good for to the press, but it doesn't even achieve mostly what it's intended to do, other than just restricting freedoms.
Thank you so much, Saurabh, for your time and all of your valuable thoughts. I hope you had as much fun, listening to yourself as I did. That we hope that you continue to be a defender of the digital freedom. Thank you so much. We look forward to hosting you sometime soon in the future for a panel or a lot of projects that we're doing.
That would be entirely my pleasure, a panel or a individual discussion, whenever. And I hope next time we meet, we can have some famous judgment which has just been passed, which none of us expected,
Yes,
which will come and protect free speech. Let's hope.
I really hope so too. Thank you. Thank you. Bye.